The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Good morning. The court is ready to hear argument in 19656, In re Texas New Mexico Power Company, a petition for writ of mandamus from Harris County and the First Court of Appeals District.
May it please the court, Mr. Subar will present argument for relator. Mr. Davis will present argument for amicus. Relator has reserved 5 minutes for rebuttal. Mr. Subar will open with the first 10 minutes and will present the rebuttal.
Good morning.
You're muted, Mr. Subar. Mr. Subar, you're muted.
There we go.
There we go.
Good morning, Chief Justice, and may it please the court. My name is Lauren Subar, and I represent Texas New Mexico Power Company. Respectfully, we're requesting that this court should grant Texas New Mexico Power Company's petition for writ of mandamus for 2 reasons. First, the Texas legislature has in very clear and unequivocal language granted the Public Utility Commission exclusive jurisdiction over the rates, operations, and services of utilities, one of which is Texas New Mexico Power Company, and plaintiffs' claims directly affect Texas New Mexico Power Company's rates, operations, and services. Number 2, the filed rate doctrine specifically allows for Texas utilities to limit liability under a utilities tariff and approved by the PUC. And this court has specifically recognized that liability limitations are a matter of the rate function of a utility. As the court is well aware, each side has presented their own view of the Texas Constitution with regard to the availability of the courts. The plaintiffs have read the first part of the constitutional provision where by the Texas district courts have exclusive jurisdiction, but they've stopped there. And as the court is well aware, the Constitution further provides that district courts have exclusive jurisdiction unless exclusive original jurisdiction has been conferred by law on another administrative body. There's no question that in this case, the Texas legislature has conferred on the Public Utility Commission all claims with regard to rates, operations, and services. As stated by the Honorable Don Willis, just before he left this court, the text is the alpha and omega of the interpretive process. And when faced with unequivocal language, the judge's inquiry is at an end.
Mr. Subar, does the text tell us in granting jurisdiction to the PUC whether it's granting jurisdiction to regulate or jurisdiction to adjudicate or both?
Both. Well, and I should say adjudicate, needless to say, with regard to things that would fall with regard to rates, operations, and services of the PUC.
Well, so what happens if there's not a regulation on point with respect to rates, operations, and services? How can the PUC adjudicate that issue? Well,
again, their interpretation is based on the Texas Utility Code and the Texas Administrative Code. And I guess the first question, needless to say, is whether the PUC in fact does have that within their rubric, within their scope. And the fact is that determination should be made by the PUC for the purpose of uniformity, because otherwise you could potentially have, and this is the perfect example, 2 different counties adjoining each other with one court saying that the PUC does have jurisdiction, does have original jurisdiction, and another court saying that it doesn't have jurisdiction.
But if we say that this has to go to the PUC, couldn't we also end up in a situation where the PUC says nobody has standing to bring this issue in the PUC, and so they're just stuck in limbo. There's no way for them to go forward in the PUC?
Well, but I
Because
think
there are
that
specific statutes that regulate the PUC's jurisdiction to adjudicate, including who has standing to raise a claim, right?
Oh, I think that absolutely. There, needless to say, are exclusions. There's also there are also places where other schemes like ad valorem condemnations, where the legislature has specifically said, look, there are times that the PUC that claims that don't come before the PUC, or that jurisdiction remains with the courts. But with regard to torts, this is not one of those times.
And so, help me with this. Are the plaintiffs in these cases your customers?
Yes.
Okay. But what's your view of why their claims fit within services and operations, but say a claim against somebody who was driving a Texas New Mexico Power Company truck on the way to check on a line would not?
That, as this court is aware, that has been raised constantly in this. And actually, this court several years ago addressed that very issue in Southwest Electric versus Grant. This court specifically said, look, a tariff would not shield a driver, a company, from liability if the employee in the performance of their duties injures someone while driving to a site. The reason being that if in fact a tariff protected against every conceivable liability, that would be against public policy. But this court at the same time noted that a tariff may limit liability with regard to negligence, where it protects the utility's ability to provide effective, consistent, and non-discriminatory services.
Here, the utility is invoking, I suppose, the tariff as a defense. The provision that's come up is the force majeure clause.
Yeah.
And I'm just wondering, we said in Chaparral that the PUC has to be the exclusive means of remedying the problem to which the regulation is addressed. But obviously, this isn't a regulation that places a burden on the utility to engage in any sort of conduct. So why couldn't a court adjudicate the claim and then simply have the tariff raised as a defense to the extent that it applies? And I'm thinking, in connection with comparative fault, for example, in this case, how could the PUC, and what issue would the PUC be asked to adjudicate if we were to say that it has exclusive jurisdiction over this claim?
Well, and I appreciate the question. And in fact, this court addressed the issue 20 years ago in the, I always forget the name of the case, the Houston Light versus Ashawn case. This court, it was great prognostication, addressed the fact that, look, the tariff, the purpose of the tariff is to, as much as anything, to regulate rates, and the trade-off for those rate regulations are liability limitations. And this court asked the very question that's kind of before the court now. Well, what would happen in the scenario where you have a force majeure type of loss? And in June, the discussion was with regard to the New York blackout. And the court specifically said, look, that's exactly why the tariff exists. The whole idea is that there has to be, without those liability limitations, you'd be unable to, customers could potentially bear an enormous risk. So to go back to your question.
What do those cases say about liability limit? I mean, I'm sorry, about jurisdiction. Grant, Oshawn, that you could recognize the tariff as being applicable to the facts, but how does it confer exclusive jurisdiction to remedy the problem to which a regulation is addressed?
Well, and it goes back to the issue of rates, because the PUC is going to be in the best position. You know, they talk about in Chaparral, they talk about the PUC, using the PUC's unique experience. And the fact is that the PUC is going to be in the best position to be able to address the problems associated with something like this, a force majeure type issue, just like in Ajun, where they were talking about the New York blackout and how that is going to affect, how those limitations are going to affect the ability of the utility, needless to say, moving forward and addressing and still being able to address those liabilities. I see I'm at the end of my time for right now, and defer to counsel for the Attorney General's office.
Any other questions? Thank you, Mr. Subar. We'll hear from the state.
Thank you, Mr. Chief Justice, and may it please the court. There's no question that the Public Utility Commission has broad exclusive jurisdiction over electric utilities. The question is whether the plaintiff's claims raise issues that fall within that jurisdiction. And in the state's view, at least one of the claims appears to raise at least one such issue, and that means that administrative exhaustion is required. If I could start by maybe addressing some of your questions, Justice Busby, about the nature of this jurisdictional grant. It's very broadly worded, more broadly worded than we see in many Texas statutes. And it includes the power to adjudicate, as this court concluded in Chaparral. No one's asked the court to revisit that determination in Chaparral.
But Mr. Davis, isn't the jurisdiction to adjudicate also shaped by the statutes that have to do with standing and other issues like that? Don't we have to take those into account as well?
No, I don't think so, Justice Busby. I think there are really separate issues. So the question of whether the legislature has granted exclusive jurisdiction is a distinct question from whether in a commission proceeding, an affected person, for instance, would have statutory standing
So you could have somebody that's basically caught in limbo where the PUC has exclusive jurisdiction, but they can never bring a case in the PUC. That seems problematic.
Well, if there was a situation like that, and I don't think any of these cases present that, and I can explain that more in the third case, but if that were the case, then exhaustion would just happen very quickly. If the matter came before the commission and said, no, there's a threshold problem here, we don't have jurisdiction to do anything, they've exhausted and they can resume their litigation in the trial court at that point.
Mr. Davis, what would the PUC's decision look like in a case like this?
Well, I don't know that we have a perfect example of that yet, because Chaparral is pretty new, but we do have an example of the PUC starting this in the Fabian matter that was cited on page 18 of the Centerpoint relator's reply brief. That's in the third case this morning. And in that case, the commission identified more than a dozen issues that in accordance with Chaparral were properly before it. And that proceeding will presumably play out and show us a model for this. I guess another point that you raised, Justice Busby, was, well, what do we do when there's no code provision talking specifically about construction mats or fuse sizes or what have you? I don't think that is a problem for finding exclusive jurisdiction here because of the nature, again, of the statutory grant. It's very broad. And I think if you compare this grant of exclusive jurisdiction to the one at issue in Subaru, that becomes clear.
But so, Mr. Davis, if the PUC can't issue a regulation and then apply it by adjudication in the same case, right? I mean, they can't apply it retroactively.
I believe that's right.
Okay, so if they haven't exercised their exclusive jurisdiction to regulate, then what standard are they going to apply if they adjudicate?
Well, I mean, I think part of the exercise here is identifying what issues are properly before the commission. And in the state's view, that's something that the commission has jurisdiction to do. Any body with jurisdiction has the jurisdiction to decide the scope of that power, and that includes what issues fall within it. And so in this case—
So Mr. Davis, is it your position that the PUC has the exclusive jurisdiction to determine its jurisdiction?
That's inherent in a body having jurisdiction, just as a court would. Of course, that's subject to judicial review under section 15.001. So to the extent that a party claimed that the commission got that wrong, it would have recourse in that matter to review that in court.
Does the court play any gatekeeping role, or does the case have to go to the PUC if one of the parties wants it to?
Yes, Justice Blacklock, the gatekeeping role for the trial court is to see if there are any issues that appear to fall within that jurisdiction, that are credibly within the commission's jurisdiction over rates, operations, and services. And if there are, and we think there are in this case, because there's a colorable defense raised under the tariff, then the commission will decide the precise scope of those. I see that my time has expired.
Any other questions? Thank you, Mr. Davis. We'll hear from the real parties.
May it please the court, Mr. Tilka will present argument for the real parties in interest.
Mr. Chief Justice.
We can hear you, Mr. Tilka.
Mr. Chief Justice, honorable justices. We represent the homeowners who are the real parties of interest, whose homes were flooded because of a mat placed next to a bayou. As a result of that, the homes flooded when the bayou's drain ports were blocked. They have now suffered damage to their shelter. They've suffered continued health and safety issues, and are faced with the daily problems of whether or not they try and repair their homes, trying to mediate their injuries, or do they make their house moves? So a tragic case in which they find themselves now embroiled in a decision as to whether or not this case, as well as all cases involving common law claims, should be presented.
Excuse me, Mr. Tilka, could I just ask you, why did your clients not go to the administrative agency first to exhaust those remedies?
We believe the matter was based solely in common law and not dependent upon any regulatory matter espoused by the legislature or encompassed in any of the tariffs.
So your client was simply just counting on that was not necessary?
Well, no, it didn't seem to be applicable. And even when we addressed this matter before the both district courts that have considered district court judges, both of them likened this matter to the absence of exclusive jurisdiction being provided to the commission in this instance, likening it to the car wreck analogy that was presented in this case, also presented in the oral discussions in the Chaparral case, as well as represented in the case decision of the Grant case back in about 2002, where they said that the matters of where they're not basically pertinent considerations to the functioning of the regulatory body, they shouldn't be applicable.
Do you see any problem with presenting this type of a case dealing with monetary damages to that administrative body?
With respect to the administrative body, the commission, I don't believe they have authority to grant the remedy. So that would be kicked back down to the district court to determine what the remedy is.
Thank you.
As I tried to look at the history of what Pura was or the PUC was and what they wanted to do, it seems like it all was going down to the business end of the utility. And then they tried to, the case law seems to all deal with cases involving the initiation or the timeliness of completion of a certain project, or the interruption or fluctuation of the service, the electric that moves up and down the line. This case falls so outside of that box. This has nothing to do with an existing utility. This has to do with a planned, hopefully planned extension of the substation that was being built. Nothing was online. There was nothing that involved the utilities functioning at that point. The contractor in this instance had not received authority to erect any poles, didn't know when they were going to get it. As a matter of fact, they said they were just waiting, kind of in limbo. And without any of those authorizations, directions, basically there's no service being performed. They're waiting.
Well, wasn't the application of the mats to the area involved, wasn't that part of the process of preparing for de-energizing the transmission line? Wasn't that part of that, quote, operation?
Well, operation is not defined by the statute. What they did when putting the mats down is so heavy construction equipment can move down when it's needed. In this case, no one knew when or if it was going to occur. As with respect to the deposition testimony we've gotten, we can also see that they had some of those mats laid alongside the road. Upon anticipation of the upcoming storm event, they withdrew and picked up and secured those mats. They didn't do that in this instance. They consciously said, we're going to take off. We're not going to follow our stormwater protection rules. We're taking off 2 days early because we might want to prepare. So all they had to do was pick up these mats and secure them. Unfortunately, when the flood happened on the first day, the mats blocked the drain port. What's interesting is after they pulled those mats out, the water dissipated and ran away.
But Mr. Tilka, I don't know if the fact that they could have picked them up means that it wasn't part of the operation.
Operation, and I don't mean that. The question is whether it's operation as defined by the statute, which it's not. Operation being putting them down, is it part of a global thing, the act of functioning? It's trying to get it there, but it's not functioning. The operation of putting something down in anticipation of what can be, I guess it could be read that far, but I don't believe so.
Mr. Tilka, Texas New Mexico Power says that these plaintiffs are suing in their capacity as customers of the utility. Do you agree with that assessment that your plaintiffs are suing as in their role or capacity as customers?
We are.
And if someone was living off the grid, for example, would their claim be any different?
I think if it was off the grid, I think the claim would be different because they wouldn't be considered an end user. In this case, we're within their geographical limitations, but they had nothing to do, no interaction with the utility about providing coverage or the extension of that matter along that easement. So I would say they're within the coverage zone. They are a unintended consumer, I guess is what it would be. They're affected by the action. And they get, because they get electricity from Texas, New Mexico, in the broadest sense, they are customers.
Does the meaning of, or the interpretation of the defendant's tariff with the PUC have any impact one way or another on the outcome of your case?
When I look at their tariff, the filed rate doctrine, they bring it down to construction services. And that tariff uses these words. It says whether or not it applies to the construction services, timeliness or the initiation or timeliness of the construction service, or the suitability of the facility that is built. And then they limit the damages. That reading has nothing to do with us. It's not the initiation or the timeliness that is concerned. We're not even concerned about the power. If we were talking about maybe a power outage in this case, they might have something to talk about, but we're not talking about that. We're not talking about an act that was encompassed in the service or the filed rate doctrine to which they referenced in this matter. There's no timeliness, no initiation issues here. And we're not complaining about the structure, the suitability of the structure.
We've said that when the PUC has exclusive jurisdiction, these kinds of claims, or at least breach of contract claims, should go to the PUC first for the PUC to resolve the issues that fall within its jurisdiction and it is capable of resolving, and then go to the courts for the courts to resolve the issues the PUC cannot resolve. I wonder if you acknowledge that there are any issues in this case that the PUC is capable of resolving.
We don't believe that there's any issue here that the PUC is capable of resolving because it falls outside of the services that the utility company has addressed, that being the timeliness or initiation of the project or the suitability of the facility. It has to do with no power outage, no fluctuation or interruption of energy. When they put the tariff together, they could have provided a more representative identification of each and every matter they were talking about. But to do a broad sweep and say all common law negligence cases should go up, I think is far afield of the argument of what is intended by the legislature in this instance.
Mr. Tilka, what if there were some claims within your lawsuit that could be capable of being resolved by administrative agency and others that were not? What do you think should happen then? Typically, in a lawsuit, because of matters of efficiency, all matters are determined in one lawsuit. And so what is your answer to that question?
I think under the hybrid approach, the best thing to do would be to abate the underlying trial proceeding, and while it's abated, go up, and then a new suit would be presented in the commission to deal with issues that allegedly relate to the pertinent considerations or the issues regarding the regulation. Once that has been determined and they make an action or they decide not to act, then the issues that they've acted on and made a decision on, or the remaining issues, would then fall back down to the district court to continue.
What about issues that are so intertwined that the resolution of the things that are not capable of being resolved by the administrative agency, in other words, are intertwined with the things that are capable of being determined by the administrative agency? And when they're so intertwined, how would you deal with that?
If if the administrative agency cannot adequately identify the issues under its purview, then all of those issues should fall back down to the court. If the administrative body is possessed of that expertise that it's supposed to have to identify those issues, it should be able to call them out fairly quickly and say, this is how it works. But
So it seems to me you're saying that it should go to the PUC first. In all of these cases, in every instance, let the PUC decide, does this have anything to do with regulation? If they say no, it goes back to the district court.
I beg to differ with His Honor in that regard. We don't believe that the exclusive jurisdiction applies in this case. Because of that, nothing we believe should have gone up there with respect to the exhaustion of remedies. It should not have been necessary.
Right. No, I understand that. But what I'm wondering is, who gets to make that decision that nothing is involved, the PUC or the court?
Well, I think the court has the ability to construe the statutes. It's inherently, that's one of the inherent judicial functions of the court. And if the legislature intended to abrogate or remove that right or duty from the court, it should have told us. And it should have spelled that out very precisely. In this instance, it did not.
Mr. Tilka, do you, you have several claims in this case. Are there some to which you think the tariff is relevant and as a defense, and others to which you think it's not, or would it, if it's relevant at all, is it relevant to all the claims?
We don't think the tariff applies to any of the claims. We have pled basically a common law claim, not dependent upon any regulatory matter, and the substance of that claim shows it. It just says, this is negligence, this is what the negligence was. And when we were able to get some discovery on these issues, there's no regulatory matter involved. There's no expertise that was required in setting down a map or picking it up. So we don't think that it applies at all.
Okay, but if you had a case where, say, you did have a tariff-based defense to one claim, but not to another claim in a case, what would we do then? I mean, ordinarily we allow, on a plea to the jurisdiction, we allow people to amend their pleadings if they can cure the jurisdictional defect. So would it be permissible in a case like that, for example, either to give the plaintiff the chance to drop the claim that where there would be a defense based in the tariff, or to ask the trial court to sever that into a separate cause of a separate lawsuit? What's your view about how that would work?
I think both of those answers that you've just given us would be appropriate. Either allow him to rethink his pleadings and take them out, or send up those that are tariff-based to the administrative body.
Let me press you still a little further, Mr. Tilka. If suppose the utility here said we had to leave the mats out to keep power flowing to our customers. If we hadn't had the mats out, we wouldn't have been able to get near the facilities and keep them functional. And that's the reason why the mats were out, and that's how they got in the bayou. Would that be a claim, do you think, that would have to go to the PUC first?
Your Honor, I think that's something I addressed earlier, and we've also presented that in our brief. If the claim had to do with the power outage and that's why they're doing it, then I think that might fall within the regulation. And that might be something that goes to the administrative body. But in this instance, there was no such power going and no such claim. Nothing was happening at all.
But again, just to return to my earlier question, who should make that determination? The court, or should it go to the PUC first?
I think the court should. They have the ability to adjudicate it. I'm sorry, I think I'm out of time.
You actually have 2 minutes if you.
Thank you. I would think that applying a broad sweep on this matter as suggested in the briefs by Texas and New Mexico would inundate and flood the administrative body with claims that would basically end up drowning them. This is not the purpose. If we have to create and expand the government interest to regulate or try and become an adjudicator of these matters, that's not the purpose the legislature intended. And the purpose is to try to move these matters as efficiently through the courts and not tie up an administrative body with matters that do not involve pertinent considerations needing their review.
Any further questions? Thank you, Mr. Tilka.
Thank you, Your Honors.
Mr. Subar, I believe you have 5 minutes.
Thank you, Your Honors. Several things. First of all, with regard to the liability issue and their argument that because they were not doing construction at the time, but that it does not fall within the services. This court specifically addressed that issue in Chaparral. In fact, in Chaparral, that this court stated, although Chaparral's claim Encore breached the contract by delaying construction does not involve rates, it does involve Encore services. The fact
Mr.
is
what precisely is the question that you would ask the PUC to resolve if you were there?
well, the PUC in this case, probably the most important thing would be to address the two big liability limitations issues. First of all, with regard to the specific liability limitations, and second of all, with regard to how the force majeure clause, which in fact is part and parcel of the tariff, how that is going to be applied with regard to the rate limitations that all utilities have. You know, we're not asking that the courts, we wouldn't be asking the PUC to make a determination with regard to how the mats are placed, but to address the issues as they relate to Texas New Mexico Power Company's ability to meet its duties to construct, operate, and maintain safe and reliable transmission services.
So you
that's-
mentioned that, sorry.
Yes, Your Honor.
If I just might, what consequences flow from not narrowly construing rates, operation, and services as it relates to the rights of people that are injured or aggrieved, either, in this type of claim? Because you're construing it so broadly to encompass everything, and certainly that has an impact. What consequences flow from that for those aggrieved?
Well, needless to say, first of all, we certainly are not going and saying that all claims. In fact, I think that this court, we don't disagree. Somebody driving to work would not fall within that. The question is when those claims directly impact the utility's ability to provide services and to provide safe services. And again, in
The force majeure clause in this case has a gateway reasonable care provision, so that a force majeure event doesn't excuse liability if there's reasonable measures that can be taken to prevent the harm. And that sounds like the duty of ordinary care. Is the PUC equipped to determine that matter? Because it's not a regulatory or legal determination. It's, could something have been done to prevent the mats from going into the bayou? Which sounds like, could the driver have done something to prevent the accident from happening? How is that different?
Well, first of all, the PUC has its own standards, the best utility practices, which the PUC uses to make those determinations. And again, there is potentially, we're not questioning the fact that potentially the overall issue with regard to whether the force majeure, how the force majeure clause eventually gets to be interpreted, but rather how the PUC essentially envisions how that is going to be, how that's going to be applied, given the fact that by the same token, the filed rate doctrine specifically addresses the fact that you don't want to have these claims for these enormous claims go and affect the rates for everybody pay to some to affect the rates for all.
Mr. Subart, let me ask you kind of in that same vein with regard to the force majeure clause. It only comes into effect if the harm could not have been reasonably anticipated. And isn't that a matter of fact, a question, whether or not the force majeure clause even comes into effect, and who makes that determination?
Well, again, and that's exactly why there are two portions to the statute. It says exclusive and original, because as this court noted, look, the PUC, their determination may be exactly that, you know what, this is not going to be something that we're going to make a decision on. But that's exactly why the language says what it says, which is exclusive original. If the court, if in fact the PUC says, look, we think that this is something that should be determined by a district court, then that issue comes back to the district court.
Any other questions? Thank you, Mr. Subar. The case is submitted and the court will take a brief recess.
Thank you.